Impact, we will learn about the Ontario Human Rights Commission's interim report on its inquiry into racial profiling and racial discrimination of Black persons by the Toronto Police Service. My name is Len Rudner, and on behalf of the Canadian Race Relations Foundation, I am delighted to have you with us today. As always, let me begin with a few administrative details. We will follow our usual format for webinars. We will begin with the presentation of our featured speaker, Mr. Sunil Gurmukh, and at the end of the presentation, I will return to assist with the Q&A section of the program. As always, you may type your questions at any time during the presentation. My colleague, Pran Nazir, and I will group or combine similar questions together in order to make the best use of our time. So let me begin. On December 10, 2018, Human Rights Day, the Ontario Human Rights Commission released a collective impact, the OHRC's interim report on its inquiry into racial profiling and racial discrimination of Black persons by the Toronto Police Service. The report provides findings relating to Special Investigation Unit investigations of TPS use of force resulting in serious injury or death, describes the lived experiences Black communities have shared during the OHRC's community engagement, and offers a review of legal decisions. As you will learn, the OHRC has serious concerns about racial profiling and racial discrimination of Black people by the TPS in use of force, stops, questioning and searches, and charges. Our speaker today will provide an overview of a collective impact and describe next steps. Sunil, welcome to our webinar, and please lead us through it.
Thanks, Len. But first, a question. How are Len, me, and you, the audience, like spiders? We are all stuck on a webinar. So before I go through the agenda, I just want to quickly introduce some people in the room that are watching. We have Fatima Dada, who's another lawyer here at the Commission, who's working on the inquiry. We have Kylie Thomas, an inquiry analyst working on the inquiry. And we have Natalie Nguyen, a special events coordinator here at the Commission, who has helped set up this webinar. And Hitan's too embarrassed to come on the frame, but he's been working with the Canadian Race Relations Foundations on all the IT. All right, so let's look at the agenda. So we're going to go through a lot of things. First, I'm going to give you some background about the Commission and its inquiry powers. Then we're going to talk about the inquiry's terms of reference, specifically its scope. We'll talk about key steps taken to date and our findings in a collective impact, areas of concern, and interim recommendations. Then we'll talk about what's happened after the inquiry, specifically the Toronto Police Services Board's meeting on December 18, 2018, and then we'll talk about what are the Commission's next steps. So the Ontario Human Rights Code is a provincial law that gives everybody in Ontario the right to be free from discrimination in policing services, including racial profiling and racial discrimination. There are three components of the human rights system in Ontario: the Human Rights Tribunal of Ontario, the Human Rights Legal Support Centre, and the Ontario Human Rights Commission. They are all creatures of the Ontario Human Rights Code. The Human Rights Tribunal of Ontario is where human rights complaints, called applications, are filed and decided. It's an administrative tribunal that hears human rights matters under the Human Rights Code. The Human Rights Legal Support Centre provides free legal assistance to individuals who believe they've been the victim of discrimination under the Code. And lastly, the Commission is an independent agency of the Ontario government. Its mission is to promote and enforce human rights, engage in relationships that embody the principles of dignity and respect, and create a culture of human rights compliance and accountability. The Commission is largely concerned with addressing systemic or institutional discrimination. On staff, we have management, lawyers, policy analysts, inquiry analysts, communication staff, and education and outreach officers. My client is the Chief Commissioner of the Human Rights Commission, Renu Mendani, and the Commission's part-time commissioners, who are all appointed by the Ontario government. They are like the Commission's board of directors. We accomplish our mission by exposing, challenging, and ending widespread, entrenched systems of discrimination, and examining incidents or tension or conditions of tension and conflict from a human rights perspective. We do this in three ways: public education, like I'm delivering today; policy development. So the Commission's policies advance a progressive understanding of the Human Rights Code, and they must be considered by the Human Rights Tribunal of Ontario when those policies are before the tribunal. And in fact, they've received deference by the courts and the tribunal. Right now, the Commission is developing a policy on racial profiling that will help organizations and individuals better identify, address, and prevent racial profiling. Lastly, the Commission engages in public inquiries and litigation. So in terms of litigation, the Commission can file its own applications with the Human Rights Tribunal of Ontario, or it can participate in someone else's application at the Human Rights Tribunal of Ontario by intervening. The Commission has also intervened in cases before other tribunals and the courts. Let's talk about the Commission's inquiry powers. All right. So the Commission's inquiry powers are described in Section 31 of the Human Rights Code. And those powers give the Commission the ability to request the production of documents or things that are relevant or may be relevant to the Commission's inquiry. It also gives the Commission the power to question a person on matters that may be relevant to the inquiry, and the ability to use expert assistance to carry out the inquiry. Concerns about anti-Black racism in policing in Toronto have persisted for over 4 decades. In 1988, Lester Donaldson, a Black man diagnosed with schizophrenia, was shot and killed in his rooming house by a Toronto Police Service officer. The police said that they were responding to a call of a man holding hostages, but found Mr. Donaldson alone in his room. He was shot for allegedly lunging at the officer with a knife. The officer was charged with manslaughter, but was later acquitted. The Black Action Defense Committee was formed in the wake of Mr. Donaldson's death, and 600 people demonstrated in front of 13 Division, where the officer worked. Mr. Donaldson's death contributed to the establishment of the Special Investigations Unit in 1990. And that picture on the left is a picture of Lennox Farrell, one of the founding members of the Black Action Defense Committee. Fast forward, in 2015, Andrew Loku, a Black man who lived in an apartment complex with units leased by the Canadian Mental Health Association, he was shot and killed by a Toronto Police Service officer. According to the Special Investigations Unit, he was shot seconds after the officer saw Mr. Loku holding a hammer in the hallway of the building. Black Lives Matter organized protests outside of Toronto Police Service headquarters and at Queen's Park in March and April of 2016, challenging racially biased policing and calling for an inquest into the death of Mr. Loku after the SIU did not find grounds to lay criminal charges. And that picture on the right is the protest of Black Lives Matter outside of Queen's Park. Mr. Loku's death contributed to the appointment of the Honorable Michael Tulloch, a judge of the Court of Appeal for Ontario, to review and make recommendations related to police oversight in Ontario. And, you know, we've heard about concerns. Indeed, the Toronto Action Plan to Confront Anti-Black Racism, which was adopted by City Council in 2017, stated that Black Torontonians face many disparities relating to law enforcement and, quote, are disproportionately impacted by racism, racial profiling, and over-policing. If you'd like, you can refer to Appendix A, which is a timeline of incidents, reports, and initiatives and cases related to racial profiling and racial discrimination of Black people by the Toronto Police Service. It's Appendix A of a collective impact, and it's a timeline from 1978 all the way to 2017. The goal of the inquiry is to build trust in law enforcement and make our communities safer. In the words of our Chief Commissioner, at the launch of the collective impact, she said, because when diverse communities trust police, they see themselves as allies of law enforcement rather than targets. This inquiry is unique because it marries the lived experiences of Black people and case law with hard data, something that is often missing in the discourse. All right, the scope of the inquiry, terms of reference. So the time period for analysis is a little over 7 years. It goes from January 1st, 2010 to June 30th, 2017. We're looking at stop and question practices. We're looking at use of force. We're looking at certain charges, arrests, and forms and conditions of release, which are on the next slide. And we're also looking at culture, training, policies, procedures, and accountability mechanisms. We're interested not only in whether there are patterns of behavior that are consistent with racial profiling and racial discrimination, but why such patterns exist. And that's why we're looking at culture, training, policies, procedures, and accountability mechanisms. And that way, we can identify the right reforms to eliminate it. All right, so what are the charges we're looking at? So we're looking at out-of-sight driving offenses, like driving without insurance or a license. We want to know whether Black people are overrepresented in these charges and the other charges you see on your slide. We're looking at simple drug possession. We're also looking at obstructing a police officer, assaulting a police officer, and uttering threats against a police officer. We're looking at, which we have heard accompany officer use of force. We're looking at low-level, highly discretionary charges like loitering, causing a disturbance, and trespassing. And finally, we're looking at failure to comply with a bail condition or condition of release required by a police officer. All right, so what are the key steps that we've taken to date? And these are all also in a collective impact. So the Commission approved the inquiry and retained Dr. Scott Wortley to provide expert assistance. That was in March of 2017. Inquiry letters were sent to the Special Investigations Unit, Toronto Police Service, and Toronto Police Services Board. Those letters were sent in June of 2017, and they're also an appendix in a collective impact. We also completed a case law review, and highlights of those cases are described in a collective impact. The public launch and release of the terms of reference were in November of 2017. We designed, or Dr. Wortley designed, the SIU data collection template, and we received and inputted the data from Special Investigations Unit's files. That started in September 2017 and went all the way to July 2018. We've been receiving data and documents from the Toronto Police Service and Toronto Police Services Board beginning in September 2017, and it continues now. We held 3 meetings with Toronto Police Service technical staff and TPS counsel to better understand their data systems, and we are engaged in ongoing outreach to Black communities. All right, so a collective impact, our interim report, is made up of 4 things. But before we go into them, what does the Special Investigations Unit do? Well, its mandate is set out in the Police Services Act. Its job is to conduct investigations into civilian serious injury and death and civilian allegations of sexual assault that may have resulted from criminal offenses committed by police officers in Ontario. It has the power to lay criminal charges. The SIU does not have the power or does not have the mandate, to investigate discrimination or non-criminal officer misconduct. It's looking for criminal wrongdoing. It's not looking for discrimination. So what are the 4 components? What are the things we looked at in a collective impact? We looked at SIU data regarding the Toronto Police Service from 2 periods, January 1st, 2000 to June 6, 2006, and the second period, January 1st, 2013 to June 30th, 2017. We reviewed SIU directors' reports of investigations involving Black people from January 1st, 2013 to June 30th, 2017. We highlighted legal decisions made between 2010 and 2017 where there are findings consistent with racial discrimination or racial profiling of Black people. And we engaged with approximately 130 individuals in Black communities across Toronto. So the Commission retained Dr. Scott Wortley, an associate professor at the University of Toronto Centre for Criminology and Socio-Legal Studies, to design the SIU data collection and analyze the SIU data. He's the expert that's providing expert assistance. He's an expert in racial profiling and social science methodology and has been qualified as an expert by the Human Rights Tribunal of Ontario, the Canadian Human Rights Tribunal, and the Ontario Superior Court of Justice. So, as I indicated on the slide before, he looked at SIU data from two periods, January 1st, 2000 to June 6, 2006, and January 1st, 2013 to June 30th, 2017. The data was collected from SIU case files. It had to be coded, meaning it had to be manually entered from case files into a database. So the SIU does not regularly collect race-based data. The information had to be compiled. So the 2000 to 2006 data was previously collected and coded in 2006 as part of the IPRWASH inquiry. And the 2013 to 2017 data was collected and coded by the Commission as part of this inquiry. So a lot of the information, much of the information, was gathered from SIU Director reports, which provide detailed information on each Special Investigations Unit investigation, including the time, date, and location of the incident, characteristics of the civilian or civilians involved, the cause of injury or death, a description of the circumstances surrounding the incident, and the justification behind the Director's decision to charge subject officers with a criminal offense or clear them of criminal wrongdoing. So, in both periods, the SIU did not provide case information from ongoing investigations or cases where the subject officers were before the criminal courts. So Dr. Wortley analyzed the data from those two periods. There were 187 completed investigations from 2000 to 2006 and 244 completed investigations from 2013 to 2017. He did not analyze cases that were closed by memo. So SIU investigations are closed by memo when early in investigations the SIU determines that the civilian injury was not serious enough to meet the threshold for the SIU's jurisdiction and was not directly caused by police activity. So SIU cases that were closed by memo did not contain SIU director's reports. How was race determined? So as I mentioned, the SIU did not regularly collect race-based data. So in the majority of cases, about 60% from 2000 to 2006, race was determined by examining photos from SIU case files. And in the majority of cases from 2013 to 2017, about 77%, race was determined by examining SIU investigator notes and Toronto Police Service documents that appeared in the case files. So how was Dr. Wortley looking at racial disproportionalities and disparities? How did he measure them? So Dr. Wortley compared the representation of three groups in Toronto with the representation in SIU investigations involving the TPS. Three groups are white people, black people, and other racial minorities. He used population estimates from the 2006 and 2016 censuses to identify the representation of these groups in Toronto. He used the SIU data, the data compiled from the SIU case files, to identify the representation of these groups in SIU investigations. So what did he find? So let's answer a big question. Are black people more likely to have force used against them by the Toronto Police Service that results in serious injury or death? So 10 years ago, the answer was yes. And between 2013 and 2017, the answer is still yes. In the words of Dr. Wortley in his written report, which is an appendix of A Collective Impact, quote, little has changed since the early 2000s. According to Dr. Wortley, a gross overrepresentation of black people in Special Investigations Unit investigations would mean that black people make up more than 26.4% of SIU investigations, or it would mean that they make up more than 3 times the representation of the population. That's the threshold. In the Ottawa Police Service traffic data collection study, the threshold was 1.5. That's what the experts from the York University used. Dr. Wortley used a higher threshold here. He used one of 3 times. And he found that black people were grossly overrepresented in Toronto Police Service use of force cases that result in serious injury or death. In 2016, black people made up 8.8% of the Toronto population. However, from 2013 to 2017, they made up 28.8% of police use of force cases that resulted in serious injury or death. 36% of police shootings that resulted in serious injury or death. 61% of police use of force cases that resulted in civilian death. And 70% of fatal police shootings. So you can see that the more serious the police conduct and lethal the outcome, the greater the overrepresentation that goes up. So Dr. Wardley also calculated SIU case rates, which allow for a direct comparison of white people and black people, even though the population of white people and black people in Toronto is different. The population of white people in Toronto is greater than the population of black people in Toronto. So in other words, SIU case rates allow us to determine whether there's a racial disparity, an unequal outcome when comparing one racial group to another. In this case, comparing SIU case rates of white people and black people. And so the case rate is calculated by dividing the total number of SIU cases per racial group by their population estimate and multiplying that number by 100,000. So the rate indicates the number of people per 100,000 population who were involved in an SIU investigation. And he found that there were serious racial disparities when you compare those SIU case rates. There were serious racial disparities impacting black people. So a black person was 3.6 times more likely than a white person to be involved in a police use of force case. 4.9 times more likely than a white person to be involved in a police shooting that resulted in serious civilian injury or death. 11.3 times more likely than a white person to be involved in a police use of force case that resulted in civilian death. And 19.5 times more likely than a white person to be involved in a police shooting that resulted in civilian death. So what is intersectionality? It's just a fancy way of saying looking at overlapping and intersecting aspects of identity. You know, when multiple parts of someone's identity overlap, like race and mental health or race and gender. So Dr. Wardley looked at certain intersectionalities. Let's talk about the first one, race and mental health. He found that white people, quote, were most often exposed to police use of force when experiencing a mental health crisis. So white people in period 2, 2013 to 2017, were overrepresented in use of force cases where the civilian was noted as experiencing mental health issues. So white people make up about 48% of the Toronto population, but made up about 65% of use of force cases where the civilian was experiencing mental health issues, where that was noted. And white people are underrepresented where no mental health issue was noted. So they make up 35% of those incidents, but they make up 48% of the Toronto population, so they're underrepresented. Black people are both overrepresented in use of force cases where the civilian was experiencing mental health issues and where no mental health issue was noted. So again, black people made up 8.8% of the Toronto population, but 16.2% of cases, of use of force cases where the civilian was experiencing mental health issues, so about twice the representation of the population. And when no mental health issue was noted, the overrepresentation was more severe. They made up 34% of those cases. So Dr. Wardley also looked at race, gender, and allegations of sexual assault. So that is part of the SIU's mandate. allegations of sexual assault. So the most staggering overrepresentation involved black males in allegations of sexual assault. So black males were grossly overrepresented as complainants alleging sexual assault against Toronto Police Service officers. So they made up 4.1% of the Toronto population, but from 2013 to 2017, black males were complainants in 25% of SIU cases alleging sexual assault by TPS officers. They were looking at case rates, they were 5.3 times more likely than black females to appear as a complainant in SIU cases alleging sexual assault by TPS officers. Black females were also 1.3 times more likely than white females to appear as a complainant in SIU cases alleging sexual assault by TPS officers. Just one moment. Got my Blue Jays cup. It's opening day today. So the majority of SIU cases did not involve a weapon. So the majority of SIU cases involving the Toronto Police Service did not involve a weapon. So in fact, from 2013 to 2017, most civilians who were involved in a police use of force case in an SIU investigation were unarmed. 67% of civilians were unarmed at the time of their encounter. So black people were less likely to have a weapon in police use of force cases. So you can see that 33% of black people had a weapon compared to about 36% of white people. So a higher proportion of black people had a gun. 8.3% of black people in use of force cases had a gun compared to 3.6% of white people. And a higher proportion had a knife. 16.7% of black people had a knife compared to 14.7% of white people. And this is in police use of force cases. But if you look at police shootings, a higher portion of white people had a gun. 20% of white people had a gun compared to 11.1% of black people. So, although there were more allegations of black people resisting arrest than white people were more likely to have a criminal record and to have allegedly threatened or attacked police than black people. And the figures are there on the slide. Black people were, and as I indicated before, they were more likely to have allegedly resisted arrest than white people. So I just want to highlight the criminal record. So 54.5% of white people had a criminal record compared to 44.4% of black people. So very few SIU investigations resulted in criminal charges. TPS officers were cleared of criminal wrongdoing in over 90% of all SIU investigations in both periods. And the outcomes did not vary by race. So officers were just as likely to be cleared of criminal wrongdoing in cases involving white civilians as in cases involving black civilians. Problems with Toronto police officer cooperation were noted in a significant minority of SIU investigations from 2013 to 2017, about 8.6% of cases, or 21 cases. So what are some examples of problems with officer cooperation? Well, examples include failure to notify the SIU or delays in notifying the SIU, witness officers not providing notes, for example, or witness officers refusing to answer questions. So, but again, problems with cooperation were no more likely when investigating a case involving a black civilian versus a white civilian. So no racial differences in outcomes or cooperation. So that is what we found, the Commission found, and Dr. Wardley found by looking at the SIU data. But as I mentioned before, the Commission reviewed SIU directors' reports of investigations involving Black people from January 1st, 2013 to June 30th, 2017, and a number of themes emerged. And there are themes that emerge that appear to be consistent with racial profiling or racial discrimination. They include a lack of a legal basis for police stopping or detaining Black people in the first place, inappropriate or unjustified searches, and unnecessary charges or arrests. This is all involving Black people. So what are some examples? So examples are highlighted in a collective impact, but I'll just go through two of them. So the first example is we can call walking while Black. So in 2015, 3 Toronto Police Service officers on bike patrol stopped a Black man for a drug investigation. They believed they'd seen the man toss away something that could be drugs, and because they stopped him because he was walking, quote, with a purpose. So under the charter, a detention means that a person is being physically or psychologically restrained, such that the person would believe on a reasonable basis that they're not free to walk away. And to detain someone under the charter, an officer needs reasonable suspicion to believe or suspect that the person is involved in a criminal offense. So the SIU director found that the officer likely did not have lawful grounds to justify the detention. So the subject officer appeared to have started with a hunch. And as we know from charter case law, the officer's spidey sense or a hunch isn't enough. So another example is a humiliating strip search. In 2013, a Black man was riding his bicycle when he was stopped by TAVIS officers. TAVIS stands for the Toronto Anti-Violence Intervention Strategy. The TAVIS unit was involved in targeted and proactive policing in at-risk neighborhoods, in quote, at-risk neighborhoods in Toronto. And between 2008 and 2012, TAVIS had the highest Black carding rate of any policing unit in Toronto. 83% of TAVIS cards were for general investigation, and 40% of these cards were of Black people. So general investigation, those contacts were not the result of a specific traffic violation, criminal investigation, or suspect description. So that's some context about TAVIS. And, you know, there are longstanding concerns about the TAVIS unit from Black communities. And so the director found that officers held each of the man's arms and asked him whether he had anything on him. After he said no, an officer pulled down his shorts and underpants, leaving his genitals exposed to the public. The officers laughed at him. The SIU director found that the strip search was unnecessary. In addition, at the man's trial, the trial judge found that the strip search was an egregious, quote, egregious violation of his charter rights to be free from unreasonable search and seizure and his right to be free from arbitrary detention. So the law, and the leading case is Golden at the Supreme Court of Canada, requires that there be reasonable and probable grounds to carry out a strip search and that the search be carried out in a reasonable manner. Strip searches in public are only allowed in the most exceptional circumstances. But here, it was in public, and the trial judge found that it was a violation of his charter rights. And the SIU director also found that the strip search was unnecessary. So when you look at the case law that was highlighted by the Commission and the lived experiences gathered by the Commission through its community engagement, the same themes emerged. Unnecessary stops questioning the searches of Black people, the use of excessive force, and the laying of unnecessary charges. So let's look at some of the case law. So we highlighted legal decisions made between 2010 and 2017 where there were findings consistent with racial discrimination or racial profiling. of black people. And two of them are highlighted in this presentation, El Marty and Thompson. So in El Marty was a civil suit against the Toronto Police Services Board. And the divisional court determined that a black man, Mr. El Marty, was stopped and searched, among other things, because of his race. And they also found that he was punched in the face, searched, and handcuffed and left in the cold because of his race. So he was spotted by two Toronto Police Service officers while walking home from prayers in January of 2011. And he was stopped because one of the arresting officers suspected that he was violating bail terms by walking alone, and for potentially having a weapon because his hands were in his pockets. His hands were in his pockets because he didn't have gloves and it was cold outside. The officers stopped the man and asked him questions. They testified that he was hostile to police and refused to take his hands out of his pockets. One of the officers, among other things, emptied his pockets and handcuffed him, leaving his hands exposed to the cold for about 20 minutes. He was not charged with any offense. So the trial judge found that the detention was unlawful, that the search of his pockets was a breach of his right to be free from unreasonable search, and that his rights were violated when he was not told why he was detained or given his right to counsel upon being detained. The police officers were also found to have lied when the court questioned them about their behavior. The plaintiff was awarded, so Mr. Marty was awarded $5,000 in general damages for the battery, $4,000 for the charter breaches, and $18,000 in punitive damages. But the trial judge did not find that there was racial profiling, and that was appealed by Mr. Marty. And the divisional court accepted the appeal and found that there was racial profiling. The divisional court increased the damage award to $50,000 for the charter breaches and $25,000 in punitive damages. And here's what the divisional court said, and this quote is highlighted in a collective impact. The only reasonable inference to be drawn from the fact that both officers, without any reasonable basis, suspected the appellant of criminal behavior is that their views of the appellant were colored by the fact that he was black and by their unconscious or conscious beliefs that black men have a propensity for criminal behavior. This is the essence of racial profiling. In this case, the officers' unreasonable beliefs about the appellant caused them to assault the appellant, unreasonably search him, and forcibly restrain him. In other words, instead of presuming his innocence, they assumed and acted as if he were guilty and dangerous. He must be violating his bail, and he must be carrying a gun. These assumptions, for which there is no explanation other than the color of the appellant's skin, cause them to blatantly and aggressively violate the appellant's constitutional rights. Thompson. In the Queen and Thompson, the court held that, quote, the real reason for the stop was racial profiling. Justice Hogan concluded that the detentions of the vehicle and of Mr. Thompson were arbitrary. There were no reasonable and probable grounds on which to base an arrest or search his pocket. He was not advised of the reason for his detention or that he was under arrest, and the force used against him was unnecessary. The charges for possession of marijuana and failure to comply with the recognizance were dismissed. He was also found not guilty of assaulting a police officer. So Mr. Thompson was a passenger in a car that was stopped by a TPS officer in September of 2011. The officer testified that the car had not signaled when switching lanes, and that once he had come in line with the vehicle, he noted that the rear passenger was not wearing a seatbelt. When stopped, Mr. Thompson came out of the vehicle as the officer got out of his, prompting a physical confrontation. The officer attempted to get his hands out of Mr. Thompson's hands out of his pockets, and a physical struggle ensued. At some point during the struggle, he was able to free himself from his jacket and fled. The officer subsequently found marijuana in his jacket, and he was later arrested and charged with possession of marijuana and failure to comply with a recognizance along with assaulting a police officer. And I described the findings in the end. Justice Hogan stated, quote, upon seeing this older vehicle being driven by three young black males, the constable's immediate conclusion, despite the lack of any evidence, was that there were up to something other than minor Highway Traffic Act violations. It was more probable than not that there was no articulable cause for the stop, but the real reason for the stop was racial profiling. Lived experiences. So we engaged with approximately 130 individuals in Black communities in Toronto, including Malvern, Rexdale, the Jane and Finch Corridor, and York Southwestern. And the same themes came up. So this quote, the first one, is particularly powerful when it comes to the theme of unnecessary stops, questioning, and searches of Black people. The quote is this: long story short, he said that there was a robbery across the street and I fit the description. I find it's always the same thing. I always match the description. They never tell you what the description is. The description is you. And when it comes to the theme about excessive force against Black people, we heard a story from a mother. She described a raid on her house in 2014 where her Black son, where her Black son was stomped on, his face injured, and racial slurs were used by TPS officers. These are, this is the perception of the family. This is what they told us. So they told us that he was handcuffed and taken to the hospital for medical treatment and was then released without charges. They told us that during the raid, another son was grabbed and handcuffed at gunpoint. And all of her sons, all of the sons identify as young Black men. The officers pulled his pants down and asked, quote, "Where are the guns?" The mother recounted that when her son responded that there were no guns, he was told that if they found a gun, his entire family would go to jail. They told us that no weapons were found, no arrests were made, and no charges were laid. The family described being severely traumatized. So we heard firsthand about the resulting fear, trauma, humiliation, mistrust, and expectations of negative treatment from police. This is what we heard from members of Black communities. One person told us, after he told us about getting stopped and asked questions about whether he had marijuana, and this was in downtown Toronto, and he was asked, he was searched. He told us this. He said, this is how he was feeling, I hope I don't get stopped again on my way home now. So we heard about the damage that one person's negative experience can have on entire Black communities, and hence the title of the Commission's interim report, A Collective Impact. Here's the quote: "The DeFonte Miller matter affects everyone in the community because it was so egregious and it was hidden and was allowed to be hidden for so long until someone else brought it forward. It is a collective experience. Someone in your family has experienced some sort of trauma with the police, so it always brings you back to that event. It's a collective impact." And what we heard firsthand about the impact is indeed consistent with social science research, and we've provided some of those references in A Collective Impact. So when you put all of this together, the Commission has serious concerns about racial profiling and racial discrimination of Black people in 3 areas: use of force, stops, questioning and searches, and charges. So the Commission made 5 interim recommendations in A Collective Impact, and they're on your screen. They're that the Service and the Board acknowledge that racial disparities and community experiences outlined in the report raise serious concerns, that the Service and the Board continue to support the Commission's inquiry, that the Board require the Service to collect and publicly report on race-based data on all stops, searches, and use of force incidents, that the Ontario government implement recommendation in Justice Tulloch's report of the Independent Police Oversight Review, and that the City of Toronto implement recommendations in the Toronto Action Plan to confront anti-Black racism. We heard statements of support from members of Black communities after the Commission released the collective impact. For example, there's the Partnership and Accountability Circle, and that's comprised of 12 Black Torontonians who guide the City of Toronto's Confronting Anti-Black Racism Unit. Their statement included the following quote. They said that they're, quote, in full support of all of the Commission's recommendations, and they demanded immediate action. They said no more studies, no more hand-wringing, no more empty gestures. This must stop. So there was also reports in the media about the Commission's report. In the National Post, Chrissy Blatchford wrote that there's a, quote, a real sense of urgency, of injury and injustice when Black people end up in such out-of-whack numbers, dead or hurt, after encounters with police. We leave it alone to fester at our peril. In an op-ed in the Globe and Mail, former chair of the Toronto Police Services Board, Dr. Alok Mukherjee, wrote that, quote, it is time for the Police Services Board to direct Chief Mark Saunders to immediately begin collecting and reporting data on police interactions with Black, Indigenous, and other racialized communities. And the Toronto Star's editorial board wrote an op-ed entitled, Police Must Collect Race-Based Data to Stem Racial Profiling. So what happened afterwards? So the service and the board issued a joint public statement after the Commission released a collective impact. And they indicated that they accepted the Commission's interim recommendations. So, but there was some confusion about the extent of their commitment in relation to data collection. The statement says that it required further study. But this recommendation is a long-standing one. It's been the subject of reports for over 30 years. So the Commission made a written deputation as a result, urging the board to require the service to, quote, collect race-based data on all stops, searches, and use of force incidents by January 2020 and publicly release data on an ongoing basis. So what happened was the commitment on data collection got firmer, which is encouraging. The board passed a motion stating that it is, quote, committed to using the collection of race-based data to promote evidence-based policymaking and organizational change, including in monitoring systemic, racial, and other disparities to identify gaps, eliminate barriers, and advance the fair treatment of every person. So the board's anti-racism advisory panel, which is made up of board members and academics and Black community members and members of the Toronto Police Service. So the board referred its collection, use, and reporting of demographic statistics policy to the Anti-Racism Advisory Panel to review that policy for amendments and make recommendations for amendments. And that group, ARAP, was directed to make these recommendations by May 2019. The recommendations will be based on best practices for the collection, analysis, and public reporting of race-based data related to complainants and victims, those arrested, those who are stopped by police, and those who are involved in incidents involving police use of force. So that policy, the collection, use, and reporting of demographic statistics, it's a permissive policy. This is how it currently looks. It doesn't require the service to collect race-based data. It simply allows it to happen. It doesn't require that that be the case. So what are the Commission's next steps? The Commission will further analyze the SIU data to see, for example, if there are patterns in use of force that flowed from initial police action that was proactive, like a police stop, or reactive, like a call for service. But remember, SIU cases are only about serious injury or death or allegations of sexual assault. So, they're about broken bones, right? They only account for a small percentage of use of force incidents. So many serious forms of force do not meet the SIU's threshold for serious injury. So broken bones meets the threshold, but severe bruises or cuts may not. So lower level use of force incidents can still have a significant physical and emotional impact on the person subjected to it. And so in the next phase of the inquiry, we're going to look at lower level use of force incidents involving the Toronto Police Service. But again, it requires compilation. This sort of data is not collected by the Toronto Police Service. The Commission will also analyze the data it received on certain charges and arrests and conditions and forms of release for adults. It will examine culture, training, policies, procedures, and accountability mechanisms and anti-racism initiatives. It will continue to engage with Black communities, and on that subject, if you're a member, if you're Black or you know someone who's Black in Toronto who has a story that's within the scope of the inquiry or more recent than June 30th, 2017, go on the Commission's website. There's a phone number and there's an email address there, legal@ohrc.on.ca, and the phone number's there. Send us an email, call us, and we'll follow up. And the Commission will engage with police leaders, officers, associations, and organizations. And lastly, it will release a final inquiry report with findings, targeted recommendations, and next steps. So thanks so much for listening to the presentation, to the webinar, and I'm happy to take any questions you have.
Okay. Thank you very much, Sunil. And we remind people who are in the audience that you have the opportunity to type your questions, and Pran and I will sort through them and present them to Sunil as they arrive. But to begin, Sunil, did the Ontario Human Rights Commission encounter any resistance or perhaps even skepticism when it did its outreach to the Black community for this report?
So what I can tell you is this. So, we participate in focus groups, and one thing we'd often hear from members of Black communities is that they've been studied to death. Why is this any different? Why do we need another report? And so what we would say is that this inquiry is unique. It marries the lived experience of Black people with the hard data. And that hard data is something that's missing. And that will allow the Commission to make targeted recommendations, to see whether anti-racism initiatives are making the situation better. And so, that's the sort of resistance we heard. And obviously, a number of Black people were afraid because they fear reprisal. And so, we take privacy very seriously. You can see that the names of people we spoke to are not in the inquiry report. And we have a privacy policy. So that's the sort of resistance we heard from Black people, and that's how we're dealing with it.
Okay. Thank you for that. And indeed, you referred earlier to an article that was written by Christy Blatchford, and I believe Christy made a very strong point that while many reports in the past have spoken about the lived experiences of the community, it's powerful, and I believe she used the word shocking, to actually see the hard data that backs up what has, for the most part, been an anecdotal or story-based anecdotes. So, two questions from our audience. The first one is, when will the final inquiry report be released? And the other question is, what is the role of public education, say from grades kindergarten to 12, in supporting this work and addressing systematically racist practices?
So the Commission expects to release its final inquiry report at some point in 2020. As I mentioned, it takes a lot of compilation because this sort of information is not collected, so we got to put it together. And we want to talk to officers, senior officers, and we got to review a bunch of policies and procedures and training. So we're expecting to release at some point in 2020. So to answer the second question, what role does education play, or what role can these students play?
Specifically, the question was, what is the role of public education, in grades kindergarten to 12, let's say, in supporting this work and addressing systematic racism?
So, my view is that public education needs to help encourage youth to be advocates, right? And so students, particularly older students in high school, they can do a number of things to challenge racial profiling in policing. They can form their own community or advocacy group at their school. They can make deputations at their local police services boards. They can participate in the conversation in other ways, through art or music, for example. And of course, they can make complaints to the Office of the Independent Police Review Director if they feel they've been the victim of racial profiling, or file applications with the Human Rights Tribunal of Ontario. And so there's also, public education more broadly is important, because it's important that black youth know about their right to be free from racial profiling and racial discrimination in policing, and what they can do about it. They need to know, when they're being stopped, what are their rights? Should they ask whether they're being detained or arrested, and what can they do? What should they write down? What should they ask? What should they do afterwards? But of course, safety is a number one consideration. So public education can play a role in terms of educating youth on their rights under the Human Rights Code, and it can also play a role in encouraging young people to become advocates.
Okay, that's very helpful. I'd like to ask my own personal follow-up question to that, if I can. In the work that the Race Relations Foundation has done around reconciliation with Indigenous people, the point that we've made, as of others, has been that reconciliation isn't just a topic for discussion between the Indigenous community and the Government of Canada. In the same way, and the previous question has pointed this out, if Toronto Police Service is engaging in practices that are injurious to the Black community, then that too is everyone's business. So I'm not in grades in kindergarten to 12, right? And when I read, for example, I know that came as a shock, but when I read, for example, about encounters that have taken place in the States where, two Black guys are arrested in a Starbucks, essentially, I suppose, for drinking coffee while Black, right? Or a university professor is stopped on the street because, despite the fact he doesn't match the description, right? He seems to match the description, and he speaks feelingly about how the only thing that kept him safe was the fact that other people were witnessing what was happening to him in a public place. So we're not talking about taking up arms, so to speak, but how important is activism on the part of men and women in the street when they see people in the Black community being treated in a differential fashion?
Activism is important. It's, we need allies. People need to speak out about it, need to call out racism broadly, whether they're the victims of it or they witness it happening. So that, and that's because it affects us all, as you mentioned, right? So, if there's research to indicate, and we've said this in our submissions to the government, that, Black people, Indigenous people, they're less likely to trust the police because of concerns about racial profiling and racial discrimination. And when that happens, when there's a lack of trust, they are less likely to provide testimony in court. They're less likely to cooperate with the police or provide a statement, and that impacts everybody's public safety. So it is a joint responsibility. We can all play a role.
Thank you for that. A question from a member of our audience. Did the Commission request data collection as a public interest remedy in cases they were involved in before the Ontario Human Rights Tribunal? If not, do you intend to do so in the future?
So the Commission requested that the Ottawa Police Service collect race-based data. This was in a human rights complaint under the old system. The case is called Aiken and Ottawa Police Services Board. The Commission settled with the Ottawa Police Services Board and the Ottawa Police Service, and as a result, the Ottawa Police Service was required to collect race-based data on traffic stops for a period of 2 years. That data showed that Black and Middle Eastern people were overrepresented in traffic stops. And so, the Commission has done it before. It is a feature of the Commission's submissions to government. The Commission has asked the government to require that police services in Ontario collect race-based data. And so we've asked for it before the tribunal, and we settled, and we've asked for it in submissions to government. And we continue to do so in the Commission's submissions to the Standing Committee about the bill, the bill of the Ontario, the bill to change the Police Services Act. The Commission again asked that the police services be required to collect race-based data.
Okay. Sorry, I wasn't sure if I was on or off. Another question from our audience. Are there recommendations emerging around the use of restorative justice for those affected?
So, I've seen a submission from the Ontario Federation of Indigenous Friendship Centers. This was a submission when the government opened up the Police Services Act, and it talked about pre-charge diversion. So instead of, charging Indigenous peoples with offenses, that there be a program of pre-charge diversion, and so where the Indigenous person would be involved in a program, and that's sort of like this restorative justice concept. But what I will say is that, in the Commission's recommendations about how to reduce racial discrimination and racial profiling of Black people and Indigenous peoples, a feature that is there is always engagement with Black and Indigenous communities.
Okay. This is while we're waiting for other folks to offer their questions, so you're stuck with another one from me. So on slide 20, I think it was, there was a suggestion that white people tended more often to engage in certain kinds of activity, either they had a police record or they were engaging or they were resisting arrest, than Black people. Yet, the other statistics suggest that Black people are more often the victims of extreme reactions from the police. I may be borrowing language from across the border, but does this suggest, as some have stated, that Black bodies themselves have been weaponized, and the mere fact that a person is Black may be seen by the police as being a threat?
Mm-hmm. So there's case law about the stereotypes that affect Black men in particular, that they're seen as gang members or threatening, and there is a case, it's called Maynard and Toronto Police Services Board, where the tribunal held that race was a factor in the officer's decision to pull a gun. So there is support for how stereotypes negative stereotypes or unconscious stereotypes about Black people can impact use of force. But looking at those particular, drilling down in the data, and the fact that we found that white people were more likely to have a criminal record, or that were white people than black people in the data, or that white people were more likely to have allegedly threatened or attacked police. When you drill down to those things, that makes the data all the more disturbing, and that's why the Commission said it calls for an explanation.
Thank you, Sunil. We're just going to wait a moment for any last questions that come up from the audience. I do have, while we're doing that, there was, the findings of the Commission are disturbing, to say the least.
Mm-hmm.
I do have one question regarding the data that was collected on sexual assaults, and I suppose it's a reflection on the times that it comes as no surprise, within the context of your report, that women from the black community would experience a higher level of reported sexual assault from police than those in the white community. I was surprised, though, with that was also found regarding black men versus black women. And this is really just a technical question, I suppose. How is sexual assault defined, or was it defined for purposes of collecting data in the report? Would this be frisks that were that were inappropriate, or cases where, as you noted before, where a gentleman was strip searched in public?
So the key is appearing as a complainant. So it involves a complaint from the person alleging sexual assault. And so, if the police decide to, if the SIU decides to lay criminal charges for sexual assault, then that can be the outcome of the case. But the way they appear in the data is such that they're complainants, where they allege that there's sexual assault. And so, what we found, the fact that black males were 6.1 times more likely to appear as a complainant in a sexual assault investigation than their presence in the population would predict, and that they're significantly overrepresented in sexual assault investigations. That's consistent with comments of the Supreme Court of Canada in the Golden case. And the Supreme Court of Canada said that, quote, women and minorities in particular may have a real fear of strip searches and may experience such a search as equivalent to sexual assault. So, it was in the example that I highlighted, and so a strip search could be the means by which, there was a complaint of sexual assault.
Thank you. That makes it clear. So if that is the perception of the complainant, then it's treated on that basis. One last question for you, Sunil, and it is as follows. Has the Commission addressed the recent comments by the Ottawa Police Services Chief Bordelot, where it is alleged that he said many young black men are involved in gang activity? That is a fact, end quote.
So, I'm not familiar with the specific statement by Chief Bordelot, so I don't know when it was made. I don't believe the Commission. What the Commission has done is it took the data, it responded to the analysis of data by the professors from York University in the traffic study, and it did find that the data was troubling and consistent with racial profiling of black people and Middle Eastern people, but in relation to this specific comment, I'm unaware of this comment.
Okay. Thank you very much, Sunil. So we are looking at our rolling screen, and you have exhausted the questions from the audience.
Well, if there are any other questions that, participants can reach out to me. My email address is sunil.gurmuk@ohrc.on.ca.
Okay. Thank you.
We have our Facebook and Twitter, and we're also on Instagram.
Okay. Excellent. So there's no excuse for people not being able to find you.
Yep, they can always find me.
Okay. Right. Well, Sunil, thank you so much, and thank you as well to the team at the Ontario Human Rights Commission for taking the time to prepare this presentation and for joining us this afternoon. I also thank the members of the audience who took time out of their day to join us, to listen, to learn, and to participate. And we look forward to seeing you at the next webinar offered by the Canadian Race Relations Foundation. Keep an eye on our website, and all the information can be found there.
Thanks to the Canadian Race Relations Foundation and all the team here behind the scenes getting this ready.
Okay. Thank you, one and
all. Thanks for participating, everybody.
Have a great day.
Thanks.